So inheritance tax used to be called death duties. It's the tax that nobody can get out of paying if they, have assets in their name. Everybody has an allowance that is tax-free, but if your assets go over that allowance, then inheritance tax is payable, and essentially it goes to the government, and it's a way of getting taxes. As I say, it used to be called a death duty, and going back to sort of the lords and ladies of the manor, they had huge death duties to pay on their very large properties. So if you have assets of more than 325,000 in the UK, you are potentially going to pay tax on anything above that at 40%. Everybody has that allowance in the UK. Obviously there are different things where you might have properties abroad or assets abroad. Although your assets are all included for inheritance tax purposes, inheritance tax is only paid in the UK. So when you leave your estate to your spouse, it's exempt for inheritance tax purposes. So if you have a married couple, they leave their estates to each other. On the first death, there's no inheritance tax payable. On the second death, so long as there have been no gifts made of more than £3,000 in any one tax year, or other large gifts or gifts into trust, then there is a transferable allowance of the full amount which will go to the spouse, so they have a double allowance on their death. So as I say, no inheritance tax on the first death, and then potentially a double allowance on the second death. Okay, so if you leave your estate to children instead of spouse, then you've potentially got an inheritance tax liability there. Your estate is exempt if you leave between spouses, and then on the second death, you've got the double allowance. So by the time it goes to the children, it may well be covered with the assets that you've got. But if you instead leave to your children when your spouse is alive, then your children are not exempt beneficiaries, and yes, there could be inheritance tax payable. So no, I do get people come to me asking how can they try to protect their assets for their family, and possibly thinking of transferring assets to their children whilst they're alive. However, if this is cash, then yes, they can do cash gifts and survive for 7 years, and then that will be out of their estate for inheritance tax. But a lot of people think of doing it with their property, and unfortunately that doesn't work. It doesn't fall into the 7-year rule, as it's considered a gift with reservation, because that person who is giving the property to their children is still living in it and receiving a benefit, so it will still be included in their estate for inheritance tax on their death.